Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as Intellect. Thank you. I see you guys. You catching on. You don't know if I'm going to come on early or if I'm going to come on right on time. So I seen it was about 65 of you guys waiting before I even came on. Thank you guys so much for your support. Make sure you hit that like button as you come in. Thank you, Tyra, for the $5 super sticker. Tyra came in and she said, let's give our girl some love for all the work she's been putting in. Because you guys know I don't come on like this. You guys might pull a good two YouTube shows, maybe a week. And that's why I was tired. I tapped out on you guys the other day when we were going over some stuff with Ernest Williams because I'm not used to this. I work full time, I homeschool, I do a whole lot of stuff. So I'm not used to this. So I'm glad you guys appreciate the work that is being put in. I was on earlier at 12:30 over on the other channel for those of you that wanted to see my commentary as it relates to the last part of the video that I just could not finish because I was tired. And I can only take so much of Ernest Williams and Sonia because it just starts sounding like, for those that's in my age group, the whole Peanut series with Charlie Brown in them, it starts sounding like wah, 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 you know, and then I just couldn't take it anymore. But I did finish it today. Yesterday, we broke over here the response to Kevin Hart's TRO. Some people were reporting that he got a temporary restraining order, which was just not true. Or maybe it was clickbait. I didn't read the article. I was just looking at the headlines. But he had requested a temporary restraining order and a show cause while preliminary injunction should not be issued. And he did it on an emergency basis. So he was able to receive this hearing on this morning. So yesterday we went over the response from Miss Shakes, and Miss Shakes was shaking it up, okay? She attached a whole lot of evidence and information and threw the kitchen sink in there that probably didn't have much to do with what was going on. I mean, it could probably be utilized if it was crafted, correctly, but she didn't care. She was just throwing everything up against the kitchen sink, and she was like, "Oh, you want to sue me? Well, how about this? Did you know about the car accident? Here's the text message I sent his wife. Oh, baby, we went through all of that. Here's the police report I filed. This is your attorney sitting up here trying to harass me. Here is an unknown number. Here are all the numbers from wherever they called me from, saying they were on behalf of Kevin Hart." Now, we went over the complaint before. That's on the platform for those of you that are new, of Kevin Hart, who filed a lawsuit against Tasha K. That's where it all began before the response yesterday. Filed a lawsuit and basically was saying that when Tasha K interviewed the former assistant of Kevin Hart, that there's some defamation, some extortion, some alleged civil conspiracy, interference with a contract. And I gave my analysis back then that I thought the lawsuit wasn't the greatest. And I felt like it was done because there may have been some trouble in the home, because Kevin Hart is not a stranger to not being the most faithful person. Okay. That's known fact. I'm not breaking any news. This is what we know. I also posed the question because he said that he felt like that interview was messing up his character. Well, the intellects, they all weighed in, and I don't think I had one person that felt like he had a family man like character anyway. And so that was yesterday. So, y'all make sure you go over there after this video. I'm going to need you to go watch and support the video that I did yesterday. Thank you so much, Baby Doll, for the super sticker. I appreciate your support. Thank y'all. Y'all coming in with the super chats. Okay. Debbie, thank you so much for the super sticker. I appreciate that. You guys, please make sure you hit that like. I'm going to try to run through this as soon as possible because I'm supposed to try to get done by 6 o'clock. Let's see how that works. I don't know. I get to talking and stuff. The law, it excites me. But today we're going to talk about the hearing that occurred for the temporary restraining order. I mentioned yesterday the fact they were trying to do an ex parte. Judges don't like doing that anyway, so it was highly unlikely that it would be granted. But Rolling Stone actually did an article and they talked about that. Andree, you said, thank you for all you do. You provided me with the needed distraction to get through this 19 diagnosis with ease. Oh no, Andrea, I'm sorry to hear that. I am so sorry to hear that. Oh, and I love you being here. Lovejoy 87. Thank you guys showing out early in the broadcast here. You guys continue to hit that like button and subscribe to this platform and also the other.
And another thing you notice, the first thing they say, make sure you guys hit that like and the subscribe button. That's what it's all about. After they get them dogging you out, before they dog you out, that's the first thing they say. If you like this video, make sure you hit.
You have 1 minute remaining.
So today we're going to talk about that. Tasha K has kind of been winning on this week, okay? Tasha K been out here like this in the legal field. You know how when you windmilling, back in the day, they don't nobody really know how to fight. Well, we knew how to fight from the hood because I'm from the hood. But they windmill, and then some of them, you don't want to catch none of them. Well, some of them done connected this week, baby, because she got a couple of wins, and we have definitely talked about some of the losses. And so we're going to be fair, and we're going to also talk about some of the wins. So on yesterday, there was a response by Tasha K against the restraining order that Kevin Hart was trying to do on an emergency basis. And we have that response. It did not post until today, like later on in the afternoon, it finally posted. It wasn't posted in the morning. But the response lets us know Tasha K said this will not be a Cardi B part 2. She said she has got her some lawyers that do civil and know what they're doing, and she is going to have them do their thing. So as you guys know, Tasha K personally was sued, and so was the company, I guess, that produces her show, Yellen. And so Yellen has entered an appearance, and they filed a response. Tasha K put in her suggestion of bankruptcy. Kevin Hart has responded to the suggestion of bankruptcy and trying to say the bankruptcy does not matter because the stay is supposed to apply to those cases, judgments that were before she filed, and she filed in May. However, what I will say, and that's what the statute says. However, while you're in bankruptcy, you do have the ability to amend it and add new lawsuits or whatever as they come. So there's that. But he responded and said he doesn't think that the bankruptcy should apply. I don't do bankruptcy, but I will say that I think it can be amended, obviously, or you add to it as things happen because she's still in the middle of bankruptcy. Either way, she has attorneys who is handling all of that. And before we get into you can tell from my title what happened today, but I think it behooves us to at least go over the response from Yellen. And I was looking at the introduction and I had to snicker a little bit because if you guys read Kevin Hart's, we read it over here, Kevin Hart's motion for the restraining order, along with his complaint, he he basically was throwing in Tasha K's bankruptcy, the whole issues with Cardi B, all of that stuff. So in the intro, you're going to see that Tasha's attorneys, or Yellen's attorney specifically, said, "Oh, we got some information about you too that we're going to put in here while you trying to act like you the family man." So the introduction says, plaintiff Kevin Hart is a celebrity and the star of, among other movies, the Jumanji films, Captain Underpants, and a 2017 sex tape that famously co-stars someone other than his wife. I said, "Oh Lord, Jesus, this how we gonna start it? This what we doing over there? Y'all, you want to talk about my $4 million? You want to talk about my $4 million? Let me tell you about your issues. Let me tell you about yourself real quick. In the first line, that was the first line. I said, "Well, damn." Okay, I got to get through this, guys. I got to get through this. Okay. Oh, Jesus. I thought that was pretty clever. I'm sorry. I like a good writing. You know, lawsuits, the writings are shade and law. That 2017 sex tape was the subject of national news coverage at the time and the subject of a widely reported lawsuit in the court. See Savage versus Hart, and it puts the case number. Hart's declaration in support of ex parte app. See also Hannah Yasharoff. Kevin Hart faces $60 million lawsuit over 2017 Las Vegas hotel room recording USA Today. Jamie Burton's article said Kevin Hart's sex tape lawsuit to go to trial. That was Newsweek of August 26, 2022. Francesca Bacardi, Kevin Hart alludes to sex tape extortion, quote, mistake, and says it's human. And that's at page6.com. So they give the notations of where you can find all of this information. Y'all still can't. Okay, I got to get serious. Okay. This action and Hart's urgent request for a temporary restraining order arise out of his objection to an interview of his former assistant, Maisha Shakes, published on December 22nd, 2023 on Tasha K Live and featuring defendant Latasha Transarena Kebe. In the nearly 1.5-hour interview, Kebe and Shakes discussed, among other things, Hart's sex tape, the public controversy surrounding and arising from its release, and Shakes' theory that the reason for which she disclosed in the interview that Hart filmed the footage. So then they put the link. Your Honor, if you would like to see the full podcast, here's the link. They also discussed the legal claims filed against Hart by the woman in the video, referencing the, quote, charges she alleges in her lawsuit. By his own admission, Hart has known about the Shakes interview for at least 2 months. He claims that he was alerted to the interview before it aired, and that his lawyer sent Kebe and Yellen a letter as early as November 22nd of 2023, demanding that they refrain from publishing it. Okay. Still, Hart waited until January 19, 2024 to ask this court to issue an emergency ex parte TRO granting an extraordinary mandatory injunction that would, one, require Yellen to remove the entire nearly 90-minute Tasha K Live episode and related promotional YouTube posts, and two, prohibit Yellen and the other defendants from any, and they did italics for any, further speech or publication, not only about the interview, but also about any related content or any other statements regarding Hart. Yeah, that was just way too broad. Like, you just saying you can't talk about me no more. That's not going to happen. The court should deny its request. Hart's delay in seeking preliminary relief, it's reason enough on its own. So then they got their case law. Long delays and assertion of rights can be the basis of denial of mandatory injunctive relief. And they have the case law for those of you that are law nerds. Even if the court were to look past this unexplained delay, Hart has not carried his burden of showing entitlement to a TRO. Most important of all, the court should reject Hart's request because his proposed TRO is flatly prohibited by the First Amendment of this here United States Constitution and by Article 1, Section 2 of the California Constitution, which provides, quote, an even broader guarantee of the right of free speech and the press than does the First Amendment, and the case law is there. Accordingly, and for any further reasons that may be raised at the hearing on Hart's application, Yellen respectfully requests that this court deny Hart's application for a TRO and deny his request for an order to show cause why a preliminary injunction should not issue. Okay, thank you, Donna, for becoming a new member. I appreciate that. Let's carry on with the actual arguments. You know, my favorite part, because I think all YouTubers should be able to know what they can and cannot do, what laws are behind them, what is not. So even though we get over here and we talk about the law on other people's issues, sometimes you can learn from these lawsuits. And this attorney has spelled out a lot in this lawsuit. I mean, not in this lawsuit, but in this response to the temporary TRO. They actually have not responded to the actual lawsuit. I would suspect they're going to respond trying to dismiss this entirely. But we'll see if that's what happens. So the argument is A, Hart cannot carry his burden to obtain a TRO. To obtain any preliminary injunction, expedited, ex parte, or otherwise, Hart must demonstrate a likelihood of success on the merits and establish that the balance of the risk of possible harm weighs in his favor. And he has the case law. And the case law stands for the proposition that affirming denial of an injunction where plaintiff offered only passing arguments and failed to meet evidentiary burden. Hart cannot do either. First of all, Hart has not demonstrated likelihood of success on the merits of this claim for defamation, the alleged harms from which are the sole basis of the TRO. So even though the allegations against Tasha, I don't believe even is defamation. It's civil extortion. It's interference with the contract. And I think some type of conspiracy. So the defamation was solely against Maisha Shakes. And the TRO basically is only about the defamation about him allegedly committing a crime with the whole sex tape situation. So then it says, Hart objects to the suggestion that he filmed a sex tape and the reference to, quote, charges that were plainly referring to civil claims that are a matter of public record. And they posted the amended complaint. And we all know we've seen that because we went over that complaint over here. He has not alleged, much less shown a likelihood of success in proving that these statements were actionable statements of fact versus protected opinion, that they are provably false, and that these statements, rather than the years of coverage of the sex tape and the legal claims against him, caused him harm. So they're saying you cannot prove that it was my interview because, baby, you was jacked up before she came on the platform. That is how you say that in layman's terms. This is to say nothing of fault. Hart concedes in his ex parte TRO application that he must prove actual malice, but his own theory that defendants should have investigated further before publishing has been rejected by the Supreme Court. So you cannot prove malice by saying if you would have investigated further, you would have known what was true and what was not true. That is not an argument. And they have the case law. Y'all hear this? Some of these YouTubers. Hart Hanks v. Connington, and that's a U.S. Supreme Court case that says failure to investigate before publishing, even when a reasonably prudent person would have done so, is not sufficient to establish actual malice. And then they have a footnote. In the footnote, it has, Yellen and the undersigned counsel are still investigating Hart's claims. have not responded to the amended complaint yet, and undersigned counsel had not yet appeared when Hart filed his ex parte TRO application. Yellen reserves the right to raise additional defenses, legal or factual, and does not mean to suggest that this is a complete list. Let me go over. Let me see if it's any other. Oh, okay. I need to read this footnote. Above, there was a footnote 1, that has Hart claims that, quote, an unidentified individual, end quote, called an unidentified, quote, Hart representative, end quote, and attempted to, quote, extort him. Yellen vehemently denies that it, Kibi, or anyone acting on Yellen or Kibi's behalf attempted to extort Hart. So they have denied that, for those of you that was wondering about that interesting claim. Let's go on to the second. Second, he also cannot show that the balance of possible harm weighs in his favor. Despite insisting that he has already suffered irreparable harm that may increase, Hart has not identified any actual harm that he has suffered or that is imminent or ongoing. And that is true. He didn't say, like, somebody, because of this specific interview, I lost gigs. Because of this. In fact, he had Lyft is actually number 1 at the box office right now. I mean, not the box office. I was getting ahead of myself and beyond myself. That's over there on Netflix. For those of you that still watch Netflix. It's number 1 on Netflix. He posted that. Hart has also posted that he's doing a comedy tour. He has all new material. So, in fact, what he's been posting contradicts any harm. If anything, it helps the case that you have not been harmed at all. That's what I would have said. I would have pulled up his Instagram in court, and I would have put it on. I'd be like, Your Honor, can I just 1 second? 1 second, Your Honor. Do you have access to the internet? Can I connect my phone? Let me pull up Instagram and let's see what Mr. Hart has to say. Oh, number 1, not the harmed guy. The harmed guy, he's number 1 at the box office. Oh, okay. Well, I'm saying box office, but y'all know I mean Netflix. I'm just tired, okay? Long day. Let's go. To the extent Hart argues he has already been harmed, the TRO cannot cure that alleged injury. The parts of the interview that Hart challenges discuss allegations already in the public sphere and are themselves now also in the public. And as noted above, Hart's delay in seeking to silence that publication is grounds to deny his request on its own. And it has the case law. By comparison, as explained below, Yellen and other defendants have a First Amendment interest in exercising their right to speak about matters of public importance. Hart's proposed TRO will unconstitutionally infringe on that right. And then it has the case law. And that case law in Columbia broad system, it stands for the proposition that the First Amendment informs us that the damage resulting from a prior restraint, even a prior restraint of the shortest duration, is extraordinarily grave. And then it has all of the case law. And I like the way they kind of added all the defendants. So even though Maisha is representing herself, this kind of encompasses everything. The ex parte TRO application should accordingly be denied because Hart has not established the grounds for issuance of a TRO, or in order to show cause why a preliminary injunction should not issue. Somebody said people are watching Lyft. That's what the man said. I'm just going by what he said gone over there on his Instagram. That's what that man said. He said that it's number 1 at the bottom. At least maybe people are checking out to see what it is. Now, they dragging him in his comments. If I was I'll be all in his comments screenshotting, because they are dragging him, baby, over there. But yeah, some people are saying it's great. I'm assuming they are Kevin Hart fans. There are some people that really think he's funny. I told you guys that, that's a subjective thing. Some people are going to think he's funny. That happens not to be my opinion, as I told you guys before. But, some people think the man is funny. Thank you, Coco JB. I appreciate that. She said, I'm the hardest working law intellect on these YouTube streets. Thank you. Love Jones said he hasn't been funny since Tory stopped writing his material. Dang, this what y'all doing to Kevin? Sheesh. You said you are not going to let losers rewrite history for the winners, huh? I got you. Love Jones. Okay, let's get on. I'm trying to beat the deadline here. Y'all make sure you hit that like button. So sub B, Hart's proposed TRO is an unconstitutional prior restraint in violation of the First Amendment. Because Hart seeks an order prohibiting a party from making or publishing statements about the interview and him, the requested injunction would be a classic type of an unconstitutional prior restraint. Y'all hear us, constant content creators? Y'all hear this? Prior restraints are disfavored and presumptively invalid. So there is a presumption, probably rebuttable, that is invalid, and then the other person has to prove, on the other side that wants it has to prove that it's valid. Moreover, under the First Amendment to the U.S. Constitution in Article 1, Section 2 of the California Constitution, quote, prior restraints are not permitted to stop the publication of an allegedly defamatory statement unless and until the question has been finally adjudicated. So basically, until we go to court and it's been adjudicated, meaning we go to trial, we do whatever we need to do, and a jury of my peers, or if it's a bench trial, I don't know why they would do that, but if it was a bench trial and you allow the judge to make the decision, it has to be deemed defamatory before you decide to tell somebody they can't post it. An unbroken string of cases from the United States Supreme Court and California Supreme Court have found that prior restraints are nearly impossible to justify in bold, and they have the law. Only exceptional cases akin to the revelation of the sailing dates of transports and the number of locations of troops and the time of war could justify such an extreme remedy. Oh, geesh. Let me say that again. Only exceptional cases that are akin to the revelation of the sailing dates of transports or the number and location of troops in a time of war could justify such an extreme remedy. Well, good gosh. The standard is so difficult to meet that the United States Supreme Court has never upheld a prior restraint against the press. And that's Procter and Gamble, and that's in the Sixth Circuit. That's my circuit, guys. That's where I'm always at when people appeal me. People are always appealing me. When I win, they appeal me. Can I just win and be great? Apparently not. Gilbert is particularly instructive. So then they have a case. So I want you guys to listen to this case that they are comparing to say that this case is very similar to this Tasha K. Kevin Hart situation. Plaintiff, a well-known actor whose personal life had been the subject of numerous articles, quote, sued a tabloid newspaper for defamation, conspiracy to defame, invasion of privacy, and more based on an article that reported accusations that she was a deadbeat mother, among other things. And then have the case law. Seeking a restraining order and preliminary injunction, the actor also alleged that the source of the article's accusations, her ex-husband, also a defendant, threatened to reveal more information unless she dismissed her claims against him. The trial court initially granted the injunction, drawing distinctions between, quote, threatened disclosure of private information and constitutional free speech issues, and disparaging celebrity news and gossip, just as Hart has attempted to do. So the trial court basically agreed with the mom, I guess, at first, and granted the injunction and tried to separate freedom of speech with threatening disclosure of private information. Well, they appealed it, and the Court of Appeals disagreed and reversed that injunction, applying well-settled First Amendment principles and emphasizing that the California Constitution provides an even broader guarantee than does the First Amendment. It concluded that while a defendant may be held responsible for abusing his right to speak freely in a subsequent tort action, he has the initial right to speak freely without censorship. At the same conclusion must follow here. So Tasha and them said, just like in that case, how the court made that decision, the same conclusion should apply in this case. Where you can't censor the freedom of speech. Thank you, GC, so much for the super chat. I appreciate you. Said, Pam, you are the best. Thank you. Yes, get these likes up. Got me over here working. I enjoy it though. Thank you. I'm glad that you guys enjoy the information as well. So in the footnotes, it looks like it's a bunch of case law that they have to support what they are saying. Because I say, where's your authority? And they have given a lot of authority. The same conclusion must follow here, where another actor claims allegedly false or private facts have been improperly disclosed. Whatever the merits of Hart's claims, and Yellen disputes them in their entirety, Hart simply cannot obtain the preliminary relief it seeks. And let's see what this footnote says. While Hart has not based his ex parte TRO application on the grounds of alleged invasion of privacy, the heavy presumption against prior restraints would apply with equal force against any such attempts. Sub 7 says, moreover, the scope of the relief, which seeks to take down an entire 1.5 hour discussion over alleged snippets of conversation, is overbroad and vague. See Evans, reversing preliminary injunction as overbroad, vague, and unconstitutional. Prior restraints before trial. So she's saying, listen, you're going to have to take me to trial to have me take this stuff down. And conclusion, for the foregoing reasons and any further that may be raised during the hearing on Hart's request, the court should deny Hart's ex parte application for a temporary restraining order in order to show cause RE issuance of a preliminary injunction. And that is the conclusion. Well, this morning over there in California at 8:30 a.m. their time, there was a hearing. And the hearing was the emergency motion for the temporary restraining order. There were reporters, obviously, in the courtroom. And one of those reporters was Rolling Stone. Rolling Stone has an article that says, Kevin Hart loses bid to get defamatory Tasha K video removed. And they put the defamatory in quotes. Let's see what they say happened in court, because I wasn't there, unfortunately, because it was just too short a notice. Because, I will hop on a plane and I will sit there for things like this up there in California. Kevin Hart can't force celebrity gossip blogger Tasha K. Kiwi to remove her allegedly defamatory interview with Hart's ex-assistant from her website, at least not yet, a judge ruled Thursday. During a hearing on the dispute in Los Angeles County Superior Court, Judge Mitchell L. Beckloff said, Hart's emergency request for a temporary restraining order failed to include a transcript of Kiwi's interview with Maisha Shakes and left him wondering if he was expected to pay the $12 necessary to view the 90-minute interview on Kiwi's website. So the judge was like, so since you didn't include the video or the transcript, so what you want me to do? Go over there and subscribe to Tasha K. TashaKLive.com. The judge was like, so what you want? Tasha K, did you want me to go over there and subscribe or something? Is that what you wanted me to do in order to see what you were talking about? Is that kind of what you wanted me to do this morning? Baby, Deb said Kevin Hart is his own joke. Sad child. Kevin Hart. Now this I'm laughing at. This is actually funny. You better put this in your stand-up, because you get a whole lot of kikis and kakas, especially that one line that was in there in that doggone brief where they said in the introduction Plaintiff Kevin Hart is a celebrity and the star of, among other movies, the Jumanji film, Captain Underpants, and the 2017 sex tape that famously co-starred someone other than his wife. Baby, that should have been the quote. That is funny. I might have to go ahead and do a short or something, because that line right there was hilarious. Whew. Yes, he is definitely helping her get her subscribers up. Listen. Oh, Lord. Okay. Let's go on. During let me see. Okay, the $12. I already said he was wondering, was he expected to pay the $12 necessary to view the 90-minute interview? Quote, part of the problem I have is that there are no direct quotes of what occurred in the hour-and-a-half interview, end quote. Beckloff complained to Hart's lawyers. He described their January 19th petition for the restraining order as, quote, just a really vague, overbroad request that doesn't address actual malice, end quote. AKA, you're not making any sense. You probably should have put a little bit more elbow grease in this motion. Hart's lawyer, Dante Mills, I mean, we heard about him yesterday and the allegations from Maisha, responded that his side, quote, obviously has the transcript, but he said they were recalcitrant, is what he's reticent, whatever he was trying to say, to file, quote, something we think shouldn't be public, because that defeats the point of the entire TRO. So he's saying, I don't really want to republish it, because then I'm basically circulating it, because I know this is public record. And so, but you can always give it to the court. You just give it to them under seal. Like you actually say, I'm submitting it in another way. So not sure what that was about. He said Hart's position is that the statement in the video are, quote, absolutely false and have caused him harm. Quote, there's no questioning them. There are things said by the speakers that are illegal. It's defamatory. It's extortion. And it absolutely shows malice on their part, Mills argued. That is pretty general. Quote, not once was there ever any claim stating that my client committed a crime until this video. I think that's important. Adultery is one thing, but adultery is not illegal. Sorry. Well, actually, adultery is still illegal in some states. They have not taken it down, because in the great state of Michigan, that statute is still up. It was actually illegal in a lot of states. Now, they haven't used it in years, but it actually was a crime, just to let them know. So he said adultery is not illegal. Okay, let's get focused there. I got 15 minutes. Judge Beckloff wasn't persuaded. I told you how the judge was looking, because I know, because, you know, we've all had that look before where they look confused, like, so what do you want me to do? What exactly do you want me to do? What exactly did you want me to do, counsel? You're not giving me anything to work with. Huh? I'm just doing my job. Like, you're not giving me anything to work with. I need you to help me out here. It's 1,400 of you guys. Please make sure you hit that like. He denied the TRO request and said Hart's camp could file a motion attempting to submit the transcript under seal, or a separate motion for a preliminary injunction in front of the judge already hearing Hart's breach of contract, invasion of privacy, and defamation lawsuit filed against Shakes and Kebe in December. So basically, the judge said, denied. You can't get the temporary restraining order. But what I will advise you to do is you can go ahead and get your stuff together, get the transcript, and you could properly submit all of that stuff under seal. And then, or you can do a separate motion for a preliminary injunction in front of the judge that is actually overseeing your case. Because this was emergency basis, they probably just had it in front of whatever judge that can hear it. The lawsuit centers on the interview with Shakes that published on Kibi's website December 22nd with the title Exclusive. Kevin Hart's personal assistant tells all. Alleged gambling addict, habitual cheater, paying millions to a man to take a DUI charges for him, and framing best friend of 30 years in fake extortion plots. He ain't talk about that. He ain't talk about the whole extortion plot thing. Hart alleges he's the victim of a shakedown. He cites in his complaint the quote teaser video for the interview that was posted on YouTube November 17th with Kibi standing near Shakes stating, quote, when you don't pay, we have to get money by any means necessary, end quote. You guys have to see the whole clip of that because when I listened to it, I was like, oh my. On Thursday, Shakes appeared in person. So Shakes showed up today. She was there this morning. She said she don't care, lawyer or not. She's about to stand up for herself. That's what she said. So she showed up. Eve said this lawsuit is so poorly conceived. KH is bringing far more attention to the interview than it otherwise would have, and KH is spending big money on a lawsuit he's likely to lose. That's what Eve B said. Fit 99 said, Kevin, you was wrong for doing your homeboy that way, midget. That wasn't nice, Fit 99. He can't help his height. Sheesh. Penny said she stood on business. She said she stood on business when it came to this here lawsuit. Tasha done went and she done hired the best over there to handle this matter. She done hired the best to get over there this time. She said, y'all not gonna see part 2. That's what she said. Okay, we only got a little bit left for this article. And then we got to get into Cardi B. So Shakes, on Thursday, Shakes appeared in person after hearing and told Judge Beckloff that Mills and another man were, quote, harassing and bullying her over the interview, causing her to fear for her safety and that of her younger daughter. The next hearing in the legal battle is set for February 29th. So Shakes showed up, and basically what she told us in that little response looked like she told the judge to reiterate. She showed the judge her complaint number. She probably came up in there with all her paperwork. She walked in there and was like, Your Honor, on February 22nd, they did this. On November 22nd. On November 22nd, they did this. On this day, this person, then Dante called, then Mike called, then Mr. Lennox called me, and I told him, don't you call me no more. You see my paper trail. Do you want me to show? Just like, no, that's okay. You ain't got to show me. I read all of your stuff. And then he's mad at me because I called his wife and all of that. And I told his wife about all his information or whatever. So she went in there prepared. She said, I ain't got no lawyer, but I'm about to tell it all. She was like, these are my confessions. Okay. Kibi, meanwhile, is no stranger to defamation allegations. A judge previously ordered her to take down more than a dozen videos and several social media posts that made false and defamatory statements about Cardi B that followed after Cardi B won a $4 million defamation verdict against her. That's that. So again, I looked on the website. They don't have an actual order. They have the minutes. And eventually the minutes will be up, and maybe I'll post it if it comes up, but they're usually like a day late. But that is an article from Rolling Stone. Now, that is that. So for now, it was dismissed, I guess, without prejudice. So was that. Okay. Let's get into part 2 right quick. So we all know that Tasha is still battling Cardi B, and she filed bankruptcy. The court has found that it was non-dischargeable because it was a malicious intent judgment, so it's not dischargeable. However, I did a short video where Cardi B's attorney filed a motion to compel. And I went over that. I think that might have been a membership thing. Yeah, it was a membership where we talked about it. But I did do a short video. So on the motion to compel that was filed, basically they were alleging in the motion, if you go watch my video, it was an upload, give it some views. It basically was they were trying to get this lady, Patricia Haywood, I think is her name. They were trying to get her to sit for a deposition. The reason they were trying to get her to sit for a deposition within the bankruptcy case was because somehow they received information that allegedly Tasha K had some accounts that were all over this world. Not just this United States of America, but all over the world, all across oceans and self-governing units and all of that. So because of that, they believe that this Patricia person has information related to these alleged accounts. And apparently Patricia was dodging. They were saying she was dodging service. She was emailed. They know that she read it because she acknowledged the receipt in the email. You know how you can click on and say that you read it and all of that. And so they wanted the judge to compel her for a deposition because she wouldn't show up when they filed the notice. And so a hearing took place. And in that hearing, the motion to compel is basically an order that will give, usually the order for a compelling of it's bankruptcy. So I'm saying deposition, but it's really a 2004 examination, I think is what they call them, but it's the same thing. But let me get my terminology right because it's bankruptcy court. So it was 2004 hearing, which is basically an examination under oath. She hadn't showed up for that, or she hadn't responded. So they filed a motion to compel for her to show up with this examination. They also wanted to give alternative service. So a hearing took place, and the order just specifically says that the motion, let me pull it up. So it has the order denying without prejudice Cardi B's expedited motion to compel Patricia Haynes. I was calling her Haywood. Lord forgive me. Haynes to comply with the subpoena for Rule 2004 examination. Deuces take them. Deuces take them just means the documents. And for the court to hold alternative service via electronic mail sufficient. So basically, it has this cause came before the court on January 24th. So that was yesterday. So it was court yesterday and it was court today. Yesterday was Cardi B, today was Kevin Hart. At 2:30, upon Cardi B's expedited motion to compel Patricia Haynes to comply with the subpoena for Rule 2004 examination, deuces take them, and for the court to hold alternative service, the court having reviewed the motion and the court file, having heard arguments of counsel at the hearing on the motion, and based on the record, does order the following. The motion is denied without prejudice for the reasons stated on the record. So basically, we ain't gonna know why they denied it unless we actually get the transcript. So of course, without prejudice, you can bring it back. I don't know. That must be a part of something else. So, of course, you can bring it back, of course, if it's without prejudice. So it looks like, based on the filings, a new renotice for her examination has been filed. So Miss Patricia is going to come on and be examined on Valentine's Day, February 14th, at the law offices of Moore and Them, LLC, because I can't say that name. And so she is scheduled for that deposition. So what I presume is that if she does not show up, then Cardi B's attorney will probably revisit it because it's without prejudice. If she doesn't show up for that examination, then they can again file a motion to compel and try to get an order compelling her. And if she doesn't show up, obviously, then that would be a defiance of the order and you can get contempt of court or whatever sanctions that the judge deems just and equitable. You said Cardi B's attorney will stand on her pockets every time they go to court. Attorney has to be paid. You said they could start adversary proceedings in the bank. They already did adversary proceedings. They started it already. That part is closed because the only issue they had was they were stating that the $4 million judgment should not be a part of the bankruptcy, the Chapter 11 plan, because the plan basically is you make payment arrangements and you almost renegotiate and contract with each individual person. So that was already pretty much done on a summary judgment. So I guess now her attorneys are using the bankruptcy to do these examinations so they can try to find where the money resides, is what it looks like. Thank you. Shar said, you, madam, are truly a legal giant. Thank you. Thurgood, he would be proud with Thurgood would be proud with some of my civil rights stuff, but some of this stuff he probably is like, can you please take me down, ma'am? And put up someone else? Because some of this is foolishness. Like when I talk about Ernest and them, he's probably like, ma'am, can you just cover my face? But when I'm up here fighting for justice and taking on the state, suing police officers, he's probably like, that's my girl. But everything else, he's like, ma'am, could you not in front of me? He probably wants me to like put a towel over him sometime. But that is like him and Ketanji, who is in the Honorable Ketanji. I don't want to like disrespect her, up there in that Supreme Court, United States Supreme Court. It's just super dope. But yeah. So I've done well. It is 6 o'clock. I said I was going to be up off of this joint. I hope you guys enjoyed the live. I think that's all I had today. Let me see. We got that one. We got that. I did the order. Response. Okay. I did it. Okay, y'all. I got to get up out of here because I have a 6 o'clock. But thank you guys so much for joining me. Make sure you go over there to the other platform so you can see my analysis and all of that stuff that I did on the end of the video on Sonia and Nesto that I wasn't able, because it does appear to be some form of the conversation did seem a little fishy. Let's just say that. People were asking me like, do you think that was blackmail? The conversation does seem to be a little fishy. And I tried to break it down because I was watching it for the first time. We did that over at 12:30. So make sure you go over there when you're off for here, because I know I try to be on a little bit longer, but I just don't have the time today. So you guys enjoy the rest of your night. I'll probably see some of you guys over here on these YouTube streets. And like I said, Tasha over. She was like, some of these swings gonna land. So shout out to you. I'll talk to you guys later. Gotta go.